So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you.
The nature of this plea originally, Judge, was obviously a little bit low. It was based on some cooperation, non-cooperation, cooperation, non-cooperation, which I believe is still the case. I don't know what.
Look this way.
What is? I don't
you
know
look
the
this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together. In that, in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well. Is that right?
Well, that's why.
They're pregnant now. Is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see kids.
And the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be. Okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
Okay.
So here's the thing. I can't necessarily order you. You're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our manager on the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go, and obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there, and that's why you called?
Yes, ma'am.
Okay.
But
then
he's
it's
been staying there.
all right. Well, then you know what you have to do. You're the one.
I got out the house and I waited on my ride before my ride came.
Well, if you're staying at the house. And you're. I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses, and so we'll come back.
This is one of those moments in court where you can actually feel the judge losing patience. You can hear it in the tone. This wasn't just about probation anymore. This was about safety. The court had already put a no-contact order in place, which usually means things were serious before this hearing even started. And yet, not only were they still talking, they were still living together, and now she's pregnant again. From the judge's perspective, that's not just breaking rules, that's ignoring every warning the court already gave. And what makes this situation hit harder is that this isn't a stranger case. This is a family case. They have kids together. They're still emotionally connected. But the court isn't looking at feelings, the court is looking at risk. And once the judge believes someone isn't following orders, jail becomes the only option left.
I would implore the court to admonish them that contact includes calls from the jail.
It does. Contact, communication. Contact doesn't just mean in person. All right? It means communication. So you can't call her from the jail. You can't talk to her. Period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to? How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, I'm trying to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's a choice that you're making to still be with somebody that assaulted you. You can go back, go.
Thank you, Judge.
You can go with the bailiff.
Do you get an updated PSI?
Yeah. I wrote on the front page, but I also wrote on that other page where it was the update.
Can I be dismissed?
Yes, ma'am, thank you.
There's not an agreement, Judge, and I do have the complainant for the underlying offense as well as Ms. Lopez here. If she may come up, I think the court might need to admonish both of these individuals per my conversation with Ms. Lopez.
Okay,
If you've gotten to the point where you're frustrated, Ms. Lopez, you know there's an issue.
so are we gonna go through the motion? Are we, what's,
Yes, please, Your Honor.
so let's do that first. Good morning, Ms. Lopez.
Morning.
And sir, you're Brandon Bell?
Yes, ma'am.
The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And will he waive the formal reading of the motion?
So
Give me just a second to get that pulled up.
This right here is where the reality of the case really hits. You can tell they both still see themselves as a couple, or at least as parents trying to stay together. But the judge isn't looking at the relationship, the judge is looking at the history. And the history says assault, probation, drug use, violations, and repeated contact after being told not to. When the court puts a no-contact order in place, it's not a suggestion. It usually means the situation has already crossed the line into something dangerous. And what makes this moment uncomfortable to watch is the fact that she's defending him, even after the assault, even while pregnant. Judges see this a lot in domestic cases. People go back. People forgive. People try again. But the court doesn't get to gamble with someone's safety. That's why the judge keeps repeating the same thing. This isn't about co-parenting right now. This is about keeping everyone alive and safe.
Mr. Bell, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to.
true or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No, ma'am.
So that would be true that you haven't successfully completed it, right? Okay. Count 7 alleges that you failed to, that
I
you
think I should say not in there, Judge, I'm sorry. He failed to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Failed to not, any objection? So 7, hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025, and is that true or not true?
True.
You understand adulteration means? If the court could explain I don't think you.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No.
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that or not? That you admitted to drinking?
So it says you admitted to the adulteration of your urine analysis, which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
Any piss test I
Urine
had.
test.
Listen.
Any urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer
Not
that you did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true, Your Honor.
Count 10. Let's see. Actually, count 9. Hold on. I'm out of 5, 6, 7, 8. What I missed here? Count 9. So this goes over here.
Now this part might sound technical, but this is actually where the case starts falling apart for him. Because probation only works if you follow the rules. And here, it's not just one violation. It's drug tests, missing programs, breaking curfew, contact with the victim, and even trying to get around urine testing. When a judge hears this many violations stacked together, the decision almost makes itself. Probation is supposed to be the second chance. But if the court feels like that second chance is being ignored, the next step is usually jail time. And you can feel the hearing getting heavier the more counts get read.
Alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
You said it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025 in the amount of $337. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 4, 6, 7, 9, and 10 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here. Let me look back at something real quick.
Hey, David. David.
When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with spinal top?
You mean mental health or
Mhm.
drug treatment? Mental health, yes.
Okay.
Yes.
Okay.
Weaver.
Oh wait, Your Honor, I apologize. August 18th was his last drug test and he tested positive for THC. He has since been drug tested again in September and it was negative. I gave you the wrong date there.
And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to that.
So,
By the time we get to this part, the outcome almost feels unavoidable. Once he admits to the contact, admits to the violations, and the probation officer starts talking about drug use again, the judge doesn't have much room left to be lenient. And what makes this case frustrating to watch is that it didn't fall apart because of one mistake. It fell apart because the same rule kept getting broken over and over again. No contact. No drugs. Follow probation. Stay away. Simple rules, but ignored too many times. And when that happens, the court stops believing promises and starts enforcing consequences.